Oh, you're Alex.
Title 1. By force of authority.
Point regarding the guidelines. Wait. Lordship has said that the letter dated 7 of July 22. It only mentions
Okay.
yes. The letter of July of 22 only mentions 135 1B. And therefore it would only be 5% as per rule 5. In fact, in the rules itself, the table is there, certainly need not be looked at. In the compounding rules, it says 5%. However, what goes to the sanction order itself? Outside, sanction order says 135 1A, 1B, and 1C. I just passed that on.
But then you have issued him a notice under 30.
Right. Not better than
So, but he never had an occasion of it.
the account is available to them. I think so far they do not know what to say. I understand. But I put this, you actually record sanction order.
May have been, yes. Even the show cause notice that you had issued was for all, but then
Yes.
when the order is issued to them, it is only for that 135 1B.
Intimation number.
Intimation.
Intimation. And intimation was to say that we are launching prosecution.
The safest word would have been if there would have been a corrigendum on your part. Or you would have withdrawn that and issued a fresh one. That would have also sufficed. Having not done, you would be bound only by 31 1B only. 135.
Not really putting my submission, I know what churches will do. I pass on this. May I say this? Lordship may put passing 2.5.
Point is, your lordship, I have confirmed with my client, he is not ready to go ahead with compounding because
That option.
your lordship may, if your lordship records that it would be reduced to 5%, so then it would be on our part. If we don't pay, it would be against it. Your lordship may decide the matter on its own merits. Regarding the challenge that is there to 722 notice, lordship may ask them to find the notice. Once and for all, your lordship may decide the matter.
No.
Because what is the
See, this was one of the grounds that you had agitated.
right? But
Then leave it on us.
And also, Lord, it has been heard after it's heard in Lordship and reserving it only for the short.
No, we had only taken up this matter only to ascertain whether that it would be 5% or 10%. He says otherwise it will be 5%, but for that error on their part, though the sanction order was for all, but then notice that has been issued is only under 135 1B.
Because which makes up this submission cannot be in after matters heard in Lordship is reserved.
No, we will not accept that also.
And it's passed on this record.
Please forward. Give a copy to the other side.
Secretary given. And this is letter and application form also are given.
lordship may decide the matter on its merits. So,
Yes.
Sorry, one other, I just wanted to bring it to your Lordship notice, though I don't rely on it, my Lord. Lordship may recall there was a CEA, wherein compounding order came to be challenged. Had argued at length of that matter. Lordship was of the view that that's an order challenged under section 129A. And not a writ petition is not maintainable against that. This is a writ petition challenging a compounding order.
No, but then. Okay.
but this is the writ
But
petition.
it's not relying on that order.
This is a writ petition which is challenging the notice which was issued.
Yes.
Responding to that, the challenge is when there cannot have been a notice for prosecution. Could there be an order for compounding? That's the case. But there was another short point where your lordship would see the circulars that are issued. There is rule 6, rule 7. Your lordship may just go through them. Because after that, there is there was a circular which was issued in 16, 17, 19, which better told. There was nothing which said that at any point of time, that the amount which was involved was either reduced or explained. It was only in 2022 that the amount was explained.
Yes.
Okay.
Like,
Because in item 2, if my name has not been printed, I'm ready with the matter, but first we kindly directed my team lead. Is there in the case status?
You wanted some other day or today?
I'll do it today.
Right. Yes.
But the impure order is at page 34. Three issues arise from those objectives. The first, my lords, is a jurisdictional issue. The appellant is an individual assessee who is also, my lords, a managing director. My lords, a personal guarantor for one company, Neo Meridian Infrastructure and Hotels Private Limited. Because that company underwent insolvency proceedings, and those are continuing. So the department appeals against the company matter. The Honorable ITAT has dismissed the department's appeal, giving them liberty to re-agitate the issue once the resolution plan is finalized. Because I made a similar submission to the Honorable ITAT. Because in my case as an individual also, the insolvency proceedings have been initiated against me. Because that submission is recorded in part by the tribunal. Because they don't deal with it. Because the provisions of law are contained in section 95 and 96 of the IBC, wherein my lords an interim moratorium is provided for. My lords can first show my lords the order of the Honorable NCL.
Do they refer to the order of the ITAT that was passed in respect of the company?
They record it as a submission, my lords, but then they don't deal with it. My lords is the impure note. Page 34 it begins, my lords.
Yes.
4, page 35.
Yes.
Per contra, learned AR submitted at the tribunal the case of DCIT versus Mrs. Neo Meridian Infrastructure Projects and Hotels in so and so, pages 16 and 23, and dismissed the appeal of the revenue on the ground that the company had gone into liquidation, and the resolution professional had been appointed by the NCL. It was submitted and the present appeal may be kept in abeyance, being filed by the director of the company. All submissions were made on merits, on the scope of 154 proceedings. The operative portion begins at para 6, but we won't deal with it at all. So I had also written a letter, my lords, to the Honorable ITAT, which forms part of the record, wherein I have produced, my lords, the orders of the Honorable NCSC, my own individual insolvency case. And we show that also, my lords, at page 436. This is, my lords, part of the record, my lords. I obtained certified copies. Because I wrote to the Honorable Members ITAT, and my lords, intimation, appointment of resolution professional in the case of so and so, personal insolvency. With reference to the above cited subject, this is to inform you that in the case of so and so, PAN number so and so, personal insolvency proceedings were initiated. The Honorable NCLT, by this order dated 9/1/23, my company petition so and so appointed so and so resolution professional bearing registration number to act as resolution professional. Meanwhile, a interim moratorium shall come into force from date of application in terms of section 95 of IBC is under. But any legal action or proceeding pending in respect of any debt should be deemed to have been stayed. The creditors of the debtor shall not initiate any legal action or proceeding in respect of any debt. Further as informed earlier to you, authority on 22/7/21, Honorable NCLT passed an order under section 95 of IBC, appointing so and so as interim resolution professional. Meanwhile, interim moratorium shall come into force. In view of above, it is requested to approach authorized resolution professional for any further correspondence in this regard. The order of the Honorable NCLT, page 437.
Now, what is the income order in both the ITAT?
My lords, the order reviewed, my lords, was the order of the Commissioner of Appeals dated 1/8/2018.
This is the issue.
The issue is on the scope of section 154 proceeding. What happened, my lords, is that there were two items of income involved. One item, my lords, was for investment by way of share application. The second, my lords, was for agricultural. The matter traveled up to the Commissioner of Appeals, my lords, only on the issue of agricultural income. I never took the ground, my lords, of the share application money being income at all in the first round of proceeding. The Commissioner of Appeals dismissed my appeal, saying that you have not paid admitted taxes under section 249 subsection 4. So your appeal is not maintainable. There was no consideration on merits. The tribunal holds that after the Commissioner of Appeals order, you went back to the assessing officer and filed a rectification proceedings on the first issue. That is of share application investment. They said it was for rectification, my lords, because what happened?
Rectification was filed on the direction of appeal.
No, I volunteered on my own, suo motu file the section 154 because it allows me to, my lords, suo motu file a section 154 rectification. The assessing officer dismissed my rectification application, but the Commissioner of Appeals held in my favor. saying that the issue that you are now raising in section 154 was never considered in the first round of litigation. You never raised that appeal, the issue was not considered, there was no adjudication on merits. Therefore, you are entitled under 154 to file the rectification. Because the Honorable Tribunal says in the impugn order that the issue has attained finality in the first round of litigation. Therefore, you cannot now have raised the section 154. So the direct section on this point, section 154, 1 subsection A. I may just show that, my lord.
Yes.
Those they permit me to read. Where any matter has been considered and decided in any proceeding by way of appeal or revision relating to an order referred to in subsection 1, the authority passing such order may, notwithstanding anything contained in any law for the time being in force, amend the order under that subsection in relation to any matter other than the matter which has been so considered and decided. So in the first round, if it had been considered and decided in appeal or revision, then I could not raise it. But if it is not considered, then I can raise it. And that's what Learned Commissioner Appeals said. In fact, that portion of the Commissioner Appeals order is extracted also, my lords, in the impugn. An exception carved out to the doctrine of merger.
Question number 1 and 3.
Plus even 2, my lords. 3 is on the debatability. The Honorable Tribunal held it's a debatable point. But why it's debatable, they never said. 2 is on, my lords, the one.
While answering 3, will that not also get covered?
That particular aspect, my lords, may not be. I leave it to my lords. Because the third question of law is only on the debatability aspect. The second is on 154 1E.
The appeal is admitted for hearing on the following substantial question.
I think Mr. J.D. Prasad himself. J.D. Prasad taking notice on behalf of the district.
So and so under instructions of J.D. Prasad and such notice and the issuance of notice.
Challenging the order of the state commission. Then my previous defects are against the to do the development work of certain lots at surveying by 89. Because few of the lot owners went before the SMD and obtained layout permission, they will give permission to us. Challenging this, all the complainants along with the respondent number 3 have filed a joint complaint before the Telangana State Consumer Commission seeking the prayer to develop the entire survey number. Whereas respondent number 3 in his individual capacity on the same footing sees development against me to his individual plot. when he files this complaint, along with written version, I filed a rejection of complaint. Alerts, the Honorable District Commission dismisses my petition saying that both parties are similar, but here there is seeking for development of the entire venture. Here he is seeking for development of his own plot. When I went in a revision before the Telangana State Consumer Commission, they dismissed on the ground, they rely on the agreement of sale, which cannot be gone into, but for the plate governments in order to rule level. And they also say that if he has filed a same relief, that does not bar. Impugn judgment, what you should see at page number 16.
Why should it not go before the National Commission?
Because the second revision is not maintainable. Because I filed a first revision before the State Commission, second revision is not maintainable. Honorable National Commission has cited that judgment also for your lordship's convenience at page 78 notes. Page 78, relevant thing is at page 79. 7. Page 70.
What of it? He's old that he was the new one. It's an old man.
Kindly see the judgment of the Honorable National Commission at page 78 notes.
Yes.
2016 SEC online NCDRC 355. Page 79, your lordship, relevant para number 7. Para 7 notes may read, since interim order has been passed to the State Commission in a revision petition, therefore on the face of it, present revision being a second revision is not maintained. Therefore, alerts, because I do not have a remedy to go before the National Commission, they can come before your lordships under 227 and say so your lordship supervisory jurisdiction where even the Honorable Supreme Court in the recent judgment of 2022 has said that I can approach this Honorable Court under 220. I pass on that order. Para 22, it pertains to the National Commission. The Honorable Apex Court, the matter pertain to the National Commission. The Honorable Apex Court at para 22 says that these tribunals are, these all are tribunals. Therefore, it is amenable to jurisdiction of this Honorable Court under.
There's no dispute on that, but then that was a matter where it was agitated right up to the National Commission, and
Yes,
then it was said,
because
after the National Commission, it is the writ court that would have the powers to,
yes,
and the concerned High Court would have, can be entered.
yes, in the instant case, because they have filed a first revision before the State Commission.
Yes.
Not go before the National Commission by filing a second revision because Honorable National Commission in previous judgments have said so that second revision is not maintained.
Your revision before the State Commission was under section,
Under section 47 1B.
and what does 51 say? 51(1).
One says no, let's appeal to the National Commission from the orders of the District Commission. State Commission.
Against an order passed under 47(1).
47.
Then why would it not be under 51?
In view of the judgment of the National Commission, which I have shown to your lordship, is
Let us take the provision first.
yes.
What does 51(1) say?
But 51(1) says any person aggrieved by an order made by the State Commission in exercise of its power compared with clause 1 or 2 or clause A of subsection 1 of the section may prefer an appeal against such order to the National Commission within a period of 30 days from the date of the order in such form and manner as may be prescribed. Now, lordship may see section 47 subsection 1. It talks about the exercise of original jurisdiction by the State Commission. Subject to the other provisions of this Act, the State Commission shall have jurisdiction to entertain complaints where the value of goods exceeds 1 crore and complaints against unfair contracts and appeal against.
One second. What was your objection before the state district commission?
District commission that
Where is that?
my petition is at page number 41.
Yes.
Page number 41. I have stated that the respondent number 3, along with few other complainants, has filed a complaint seeking for development of the entire venture in survey number before the state commission, which is already numbered by CC 43 of 2022. Again, in his individual capacity, he comes before the district commission and files a complaint saying that he developed my individual plot in that survey number. When I challenge that before the district commission by filing an IA for rejection of complaint, it says that yes, both parties are similar. It covers the entire venture, whereas it covers only his individual plot. But my respectful submission before the district commission, state commission, as well as before Lordships is this: that when his entire plot is being covered, when he's already a similar party before the proceedings before the national state commission in a consumer complaint, where he's seeking for the development of his entire plot. Entire survey number, which includes his plot, again he cannot file a complaint for development of his individual plot because already it would be covered by the.
The matter is still sub judice before the district commission.
Yes, district commission.
You have raised an objection in this regard before the district
Yes,
commission.
sir.
So rest would be factual. You will have the chance to prove your case by leading appropriate evidence.
Because,
Why snap it at this stage? That too at the second revision stage.
my respectful submission would be this manner because by reading of his own prayer.
Correct. You have raised that objection that has been considered by the district commission, and then this would be there.
Yes.
You can lead appropriate evidence on merits and then establish your case.
But they agree to my contention that yes, both prayers are almost all similar. It covers his venture, but it does not parse him. My respectful submission is this: in view of section 10 of CPC and also judgments of the Honorable Apex Court, if there is a similar prayer in the two suits, it would be against me, my lord, because assuming for a moment without considering, if both orders come against me, there will be two execution applications hanging on my head, where I will be prosecuted twice for the similar complaint when he's getting benefit here as well as there.
That is you are apprehending.
No, I'm saying assuming without considering, my lord, even the state commission, my lordship may see the impugned order at page number.
Yes.
Page number 19, the relevant impugned judgment.
Yes.
There are 12 members. The essence of the agreement of sale shows that the opposite party petitioner has committed to release the mortgage from HMDA, and the complainant respondent cannot hesitate in the state commission for this particular relief in view of the consideration paid. Now, seeking a relief that is common to the other purchasers does not preclude him from stating his individual claim or right. They reject my complaint on by revision of the two grounds, saying that they rely on the agreement of sale, which cannot be gone into at the time of considering this revision in the rejection of claim. They go into the agreement of sale and say that my plots are mortgaged with the HMDA. It is a general rule under the HMDA Act. If I want to develop my plot, I have to give my plots to mortgage before the HMDA. After I develop the plots, HMDA releases them. That prayer is covered in the prayer before the state commission also. My lordships may see that at page number 30, where his prayer starts, joint complaint. That page number 38 is the main prayer, lordships. Page 38. There is one. Page 38.
Who is the complainant in CC 43 of 2022?
The respondent number 3, along with all other complainants, they have filed a joint complaint seeking for the development of the entire survey development, which includes his plot. He is the party there before the state commission.
The district commission has proceeded to decide both the matters together. The matter would be examined. You will be permitted to lead appropriate evidence, and an order would be passed, which would be equally applicable in both the cases.
My respectful submission is this, because state commission is already adjudicating, and again district commission will be adjudicating on the same issue. My lordships may see one judgment of the Honorable Apex Court. What is the test of section 10 at page number 76? 76, my lord, the relevant portion, which starts at page 71. Teacher versus
What if he would not have been a party before the state commission?
his complaint would have been maintainable because his individual grievance,
He can still get his name deleted from that proceeding.
but he's not doing that.
That's a different thing.
Even otherwise, you are bound to develop the plot.
Yes, I'm bound to develop that are the factors which have to be gone into the merit. It is already is my respectful submission is that his right is not getting affected if because his all rights are already there before the state commission which is deciding this complaint.
Your defense is also not at this juncture getting adversely affected.
It is not, but my respectful submission is that because similar prayer for development of the same plot, different complaints would be coming is my respectful submission.
Yes. Doesn't this the reputation point us against the other? Yes.
Is a matter arranging the income tax act. Plus the petition before my lord in the society registered under section 12A. It is a government society lords functioning under the Youth Advancement, Tourism and Culture Department, the government of Telangana. Because it is headed by the Chief Minister lords and the main function of the main object of the society lords is to promote the arts and culture lords apart from providing support to artisans across the state of Telangana. Look, the assessment year involved is 17-18. What has happened initially, Milord says, there was a delay in filing an audit report. Milord, along with my return of income, I have to file an audit report. There is a delay. Admittedly, there is a delay, and the audit report has been filed much before the assessment. Because Lord, may kindly have a look at the audit report at page 56.
Yes.
It is filed on 1/10/4/2019. While the assessment order is dated at page 59 on 24/9/2021. My prayer before my lords is twofold, Lord, before I get into the facts. First thing is, Lords, there is a delay in filing the audit report. I filed an application before the authorities to condone the delay. That was being rejected, which has not been communicated to me. Now, what has happened is at the stage of assessment, since the audit report is filed belatedly and the delay is not condoned by as on that date, the SC officer disallowed the benefit which is available to me under section 12 and and added the entire sum to my assessment. And I filed an appeal against that. In the appeal notes, the appellate authority writes some other order which is not even relevant to facts of this case. He copy pastes the order of another year instead of this year, instead of raising this issue. Now, let us come to the first round of not condoning the delay as regards my 12A application, as regards the belated filing of audit report. Lords may kindly have a look at page 59, that is the assessment order. And at page 63, my lord, this is the addition made by him. Lords, against which I don't have an alternate remedy, my lords, in not condoning the delay. Page 63 is the paragraph 4. During the year, the SC Trust claimed exemption of rupees 12 crores and odd, and the same was disallowed by the CPC under 143(1) dated 21/2/2019. With the reason that the SC Trust has not filed audit report in Form 10B along with or before filing return of income. The exemption under section 11, that is serial number 1 to serial number so and so, is not allowed. The return of income so and so as per CPC computation. The return income is so and so as per CPC computation. On verification in the system, it is found that the SC Trust filed its audit report in Form 10B on 10/4/2019. They admit that I have filed it before the due date. Because there is a circular issued by the board way back in 1978, it is settled even as on date. If I file the audit report before the assessment stage or during the assessment stage or worst scenario during the appellate stage, the authority cannot throw me out. This is the board circular of 1978. It was dated 9/2/1978. The board have considered whether the requirement under section 12AB of filing audit report along with the return of income is mandatory so as to disentitle the trust from claiming exemption under section 11 and 12 in case permission to furnish such report in prescribed form along with the return. Normally, it should be possible for the charitable or religious trust or institution to file auditor's report along with the return of income where such trust or institution claims exemption under section 11 and 12. However, in cases where, for reasons beyond the control of the SC, some delay has occurred in filing the said report, the exemption as available to such trust may not be denied merely on account of delay in furnishing the audit report, and the ITO should record reasons for accepting a belated audit report. Because following this, our High Court will not say 285 idea. This is a case reported in 285 ITR, page 147. Internal page 2, Milords, paragraph 1. The questions are recorded, Milords. Whether on facts and circumstances of the case, the ITAT was correct in law in directing the SC officer to allow the benefits under section 11 of the IT Act. Whether on facts and circumstances of the case, the ITAT was correct in law in holding that provisions contained in section 12AB are only directory and not mandatory. At paragraph 6 on page 4, Milords, they refer to the circular what I have just read out, Milords.
Yes.
Paragraph 6, Milords, at page 4. And if I may draw my lord's attention to paragraph 8, Milords, in the bottom of that page. Coming to the first argument that section 2, Lordship got it, Milords,
Yes.
that section 12AB is mandatory. Learned counsel appearing for the SC relies on judgment of Bombay High Court in case of CIT versus Nagpur Hotel so and so. One of the questions which was before the Bombay High Court was whether on the facts and circumstances of the case, the ITAT is correct in holding that the application in Form 10 under Rule 17 of the IT rules could be filed even after the assessment is completed. The SC in this case claimed exemptions were in paragraph 10 Milords. The court held that the IT rules could not fix a time limit for submitting applications in Form 10B under Rule 17, paragraph 11. The reference has been placed by some other judgments also, but in our opinion, the matter can be disposed on the ground that there is a circular which has been reproduced here in above, which lays that exemption under section 11 should not be rejected only on the ground that there is a delay. There has been a delay in filing the report by the accountant in terms of 12AB. There is a direct judgment of the Honorable Supreme Court in paper and so and so paper codex. But they say that this judgment refers to a case where the circulars are binding on the departmental officials and they have no other way out. The paragraph 12, my lord, since the Supreme Court has laid down that the department has no right to challenge the circular issued by the board on any ground whatsoever, including the ground that it was inconsistent with the statutory provision. Because identical view has been taken by Calcutta High Court, Punjab and Haryana High Court, and the Gujarat High Court. Latest view, my lords, is at 125 taxroom.com.
Yes.
This is in the case of Sarvodaya Trust, my lords. Sarvodaya Charitable Trust. And the questions, my lords, not the issues, my lords, that was also a repetition. The first paragraph, my lords, internal page 2. By this writ application under Article 226,
Your condone application was under section.
that's section 190, my lords, 192B. Plus 190, my lords, instructions to subordinate authorities. And at 2B, my lords, we make these applications to the authorities. In the present case, it will be the jurisdictional CIT, my lords, jurisdictional commissioner will be the third respondent before my lords.
What do you say?
They correct the benefit, my lord, because on one hand, he says that, my lord, he has not filed an audit report within time. And on the other hand, my lord, in canvas, he has not issued any notice. But my lord, its burden lies on that, my lord, he has to furnish his correct address. Well, it's a Shilparamana is not a small entity, my lord, that he has not issued any, because all writ affidavit will show that, my lord. Right from 2017 to 2023, he has not even received a single notice from the department. This is which is highly unbelievable, my lord. That's what my letter is. I'll file screenshots also to that effect, my lords. You don't can see the entire writ affidavit because I've gone through the annexures filed by my friend. But when I says that at any point of time, he has not received the notices sent to the department. And it's not that when it's
What is the order of the authority? How has he dealt with authority who had heard on the application under 109, 19?
I'm getting stressed for it. That is the case. Not scale is 14 or 15 minutes because now they have April order is issued on directly to place a remote on another people 15. You know, straight put the matter 15 minutes getting stressed.
See, the very purpose of 119.2 was in order to avoid genuine grievances.
But the fact means that all the what is it?
No. The term used is to avoid genuine hardship, which means that the authorities concerned are to take a pragmatic view rather than a stringent approach. The audit report is there. It is submitted before the assessment order is passed. Then why a stringent approach? And look at the wordings. We have outrightly rejected it without any discussion. That is not what is mandated.
I'll get it. Because even late hours, we received information. We received a mail from the bilateral mirror. It's fine. In fact, I forwarded this in the morning. That's very good.
When? 15?
I have already been threatened yesterday itself. Since the writ has been filed, now with the benefit I have given till 15th is gone. We are going to get a Diwali gift. Is the threaten I have received from the outfit. There was nothing we have to do. Let my friend know I come against your office. I have because I have utmost respect to my friend, but I respect my officer not to take it. Right now I forward this what message to the this thing.
We expected no co-sister to be
Yes,
taken.
as a state government, it's not that I am fly-by-night operator or I'll run away. In fact, it's a landmark in the West. It's almost a landmark in the new city today.
I have no idea.
That's what I'm doing. I don't want to fly-by-night operator. It's an institution which has been established nearly 25 years ago.
Yes, we can. What is 5?
Because 5 is 151 ADUs.
151A.
3015.
Who's there for the other side? Yes, same order. Yes.
Yes.
You have to.
Let's take them over lots. We kindly have it in the social list in the special.
We ordered for treasury admission.
Very like.
Yes. Five is allowed. Huh?
Respect of the house property, there are we should start waiting. Perhaps who should start waiting before the 17th senior citizens incident. One is well. OS 311 of 2021 has been filed by the Commissioner. The defendant number 1 is the same suit has filed another suit pilot, that is OS number 201 of 2020.
Just one second. Can you just repeat that once again?
Yes, pilot in respect
Yes.
of the.
Is Shashi?
Yes, I appear for R3, your lordship.
Yes.
Yes, sir, yes. But in respect of the house property pilot.
The order under challenge is page 12.
Yes, this is page 12.
This is disposal of an OS.
Yes, ma'am.
OS 412 of 21.
Correct.
The plaintiffs there is Saftar Mirza and Jayashiv Shakti.
Yes.
They are the advocates.
Yes.
They are the advocates. Who are the plaintiffs? Where the cost item?
Upstate is page 12. Kavish Khadri is the plaintiff pilot. Muhammad Alimuddin is the defendant.
Defendant, right.
Pilot.
The suit was for?
Suit was for specific performance. The basis the basis of an agreement of sale, that agreement of sale is on page 61.
Yes.
Even the first party is nowhere concerned, and the second party is nowhere concerned with the property.
Where is that agreement to sale? Is it on the record?
61.
Page 61.
61.
Who's Ahmad Saeed?
This is stated. I must say it is the owner of the property. I must say it is the owner of the property. I must say it expired. He was issueless.
When?
I must say it may not expired. Until 5/2021.
13.
5/2021. I must say it expired. Yes, even before the suit.
Before the suit or pending the suit?
Before the
Suit is of 21. Sir.
yes, I will. The 13/5/2021, I must say it expired. His wife Atya Sultana also expired on 15/5/2021 within a gap of 2 days because they were affected with the COVID. They were admitted in isolation ward. They expired in the hospital itself. And both were issueless. There were no issues. With dispute arose, my lord, who should succeed to the property of the business person. Two suits were filed before the 17th Senior Civil Judge Civil Court at Hyderabad. One suit is, my lord, OS 311 of 2021, filed by the petitioner here seeking declaration in injunction on the ground of success.
311 is suit for?
Suit for declaration and injunction, filed by the petitioner before your lordship.
Yes.
OS 311 of 2021, and dependent in the same suit, dependent number 1 has filed another suit, that is OS number 201 of 2022 before the same court.
201?
201 of 2022. And
Defendant in the suit by the petitioner.
by the petitioner, he filed another suit.
What is his name?
Not one. 201 is Ghulam Mohammad Tahir, Alimunisa Beg. Both filed. Ghulam Mohammad Tahir is also known as Muhammad, and dependent number 1 was 311.
That suit was for?
This is also for declaration.
Declaration.
Both were seeking declaration on the basis of succession. What happened in OS 311, he claims the property through paternal brothers. Here from the lady method, 40% claims the property. Both suits are pending before the 17th Senior Civil Judge Civil Court for adjudication. Meanwhile, this person perished now. The person will not. The respondents 1 and 2 and the similar. Now they, when no they concerned with the property, they come up with this agreement of sale, which is appears reported one. Page 61 is the agreement of sale. On the basis of this agreement of sale, the second party purchaser, that is a Kavish Khadri, files a suit before the court below. That suit is Mellon. OS 4/12/2021, the plain copies are page number 15. Mellon.
He claims to be the purchaser.
He claims to the purchaser.
From the agreement dated 13/3/2019.
Yes, well, 13/2/2019 is the date of the agreement.
13 or 3/2?
3/3/2019.
Yes.
On the basis of this agreement, he files a suit. That is suit is OS is 4/12/2021. That is on page number 15. Now he filed this suit against Muhammad Alimuddin. Muhammad Alimuddin is not the party in both the suits. Both the suits are being conversed with different parties.
What is the status shown in this suit of Muhammad Alimuddin? What is he?
He says he is a foster son, adopted son of the original owner. There is no such thing. Alimuddin is a stranger. The Kanushkat is also a stranger. Both of them may not find his suit. There is a police suit obviously, and defendant may not says himself exploited. They find a compromise agreement. Can you see that agreement? They find a compromise agreement, compromise terms of compromise.
What is the present status of the property?
But is in the position of the petitioner.
Suits are still pending.
Suits are still paid.
How is the petitioner related to the original landowner?
Original landowners, brothers, own brothers.
And what is the stage of that suit?
Pending for the trial. Now, I think.
Both have been clubbed together? No.
Now, what happened In that suit also, OS 201 also expiry degree was obtained. We got it challenges. Now it is set aside. Now both the suits are now will be coming on 14th, I think.
So joint.
Yes.
Petition is admitted for hearing. Yep. Mr. Shashi, we are admitting it.
Yes, Your Lord.
Special.
Mobilized. Mobilized.
Filling popular, this motion has underwent heart surgery. Timely accommodate board, council has issued notices to all one that was answered. Question.
It's an appeal for enhancement. It's an appeal for enhancement. It's an appeal of 2015. We will mark your presence and then we'll proceed and decide. We will ensure that no harm is caused to you. Anybody there for Oriental Insurance? Where is Mr. Ramakrishna Reddy? Mr. Sukaro, you are also there for Oriental?
Question only you wanted to add on me.
No, really.
It was answered.
This. Look for Ramakrishna. Call Mr. Ram. He also. You are there for Oriental.
Yes. Also, pick up this focus.
We want your help to enhance the compensation. Accident is 21011.
It's a dangerous. It's also
Catalyst.
spine injury, D11 and D12.
Permanently bedridden. He was running an auto rickshaw.
Examine the doctor, it's PWD is the doctor in there of 10 minutes. 90% is okay.
Actually, there is no dispute.
Because now there's a reason why I've seen because joint and circle liability is given. Therefore, I cannot go for that thing.
That's what I said, that
Yes.
actually there is no dispute.
Now we have to
The
consider
thing is,
paragraph 10 of the statement. Check whether the civil assistance settings was it was that running internal page 5 minutes, running page 10.
in all these cases, they have all been examined, but then were they examined by commission or were they brought to the court under such a state of condition?
But normally, they brought the petitions for it. If necessary, then the commissioner will go. Otherwise, in case of human rights, we ourselves for going and examining.
Only 6,000 has been
Yes,
excessed.
6,000 was taken. I mean, even Supreme Court also corrects now 8 to 9,000 are taken for a driver.
For a driver, he's an auto driver.
Yes,
He has an auto there.
it's a driver is holding the transport license. They are not we can treat him as a profession as a driver, not it's safe. Yes,
We'll take it at 10,000.
plus 40% because it's
300, 400 rupees a day, 500 a day is very easy for
stable
him.
the 2,000.
They said, even at that point of anything subsequent to 2010.
I'll put it 300 euro, you will take it at 9,000. That will be reasonable. Another 40%, but 3,600, that will come to 1,000 because now it's not case where deduction cannot be applied in this case because we are taking it as 12,600. Even otherwise also.
No.
Yes.
Even for a manual labor or a semi-skilled labor, 300 would have been reasonable. He is earning his income by an auto. We know.
So even after excluding all the expenses, that's even for contribution, let us take it as
10,000 seems to be reasonable. I mean, it's not that far. 10,000.
42 years.
Age is 42.
42, well, I to the cost because as the date of accident, we need to check it.
Disability will be 100%.
Yes, but the claim it is final section in the year 2012. Even according to him, already says so. Even 2012, he said that 42 years. Therefore, already is above 40 years.
Yes, there's no dispute on that. He is above 40.
40 years, already the 25% of 10,000. That will another 2,500, 12,500 into 12 into
10,000 plus 2,500
yes, 12,500 into 12 into 14 million.
into 12 into what would be the applicant multiplier?
41 to 45 is 14.
14.
Yes. Become 21 lakhs. Yes. Certain medical expenses also came.
21 lakhs.
Yes, 21 lakhs. The tribal given my medical expenses. $32,800.
How much?
32,800. You are actually find it page number 6.
Internal page 6.
Internal page 6 text after the loss of earnings. According to the claim is entitled to 32,800 towards medical.
Why only 32,800?
Because he must have taken the treatment in the government hospital.
Or okay.
Private hospital private hospital. But evidence shows that it's 32,800 towards medical expense, which produced the claimant about worth rupees 15,000. According that is entitled to 60,000 towards payments. That will enhance it to parents of people. Because
60,000 is nothing.
yes. Altogether, it's you are paying.
What about future expenses, medical expenses?
It was coming to the science of
Because the condition is,
first.
yes, that would have some future.
But so the disability of whole body 30%. So if I could determine the insurance, that in science case.
Future treatment will add another 2 lakhs. And what about pain and suffering? 60,000 is
That's the reason why I said so. You are annual to the person. Another 2 lakhs for parents.
as I always say, these are conditions worse than a fatal case.
Yes. This is lifelong.
Not just the person who's met with an injury. The entire family goes under a tremendous trauma.
The 2 lakhs will be towards this. And here is a case when application like is also there. Case of like everything is there.
That is also there.
Yes.
An artificial limb, cost for artificial limb.
Even if otherwise also, if that's artificial. Yes.
I know his mobility. Otherwise, his mobility is confined.
Mobility is restricted, therefore there is no use even for the artificial.
We'll add 5 lakhs. Amputation, that has added more to the injury, the amputation part. No, there is another element which needs to be considered. What about engaging an attender? These are cases where there would be requirement of an attender all through his life.
Throughout his life.
That has not been considered. Three lakhs for pain and suffering, another 2 lakhs for attender.
Two lakhs is not your hospital parents.
3 lakhs for pain and suffering, and 2 lakhs for engaging an attender, which again is on the lower side.
Your future medical benefits under 2 lakhs.
Is only reaching 28.
28 lakhs, 32,800. Because that medical expense also you have to put.
Somehow we want to touch 30.
No, you will reach it with 38 to 40 lakhs because the interest will come and everything. And almost it touches 40 lakhs. Yes, we see.
No, some other lady council is
That's my friend.
okay.
They're not 90% disability on.
We are treating it as 100. We are treating it as 100. 6,000 has been assessed. We are taking it at 10,000 salary.
40% is the 30%.
25% is the future prospects.
But you are getting 21 lakhs.
Present is an appeal by the claimant under section counsel who has rendered appearance for the Oriental Insurance Company at the direction of this court for his legal assistance would be entitled for the professional fees as is paid for the panel lawyer for the respondent number 2 insurance company, which is expected that the respondent number 2 company shall honor.
Hey, there are the things. Then just make them up.
It's not requested to next week, but requested.
You are for the
Requested to petitioner. Tuesday.
just remind we will take the assistance of Mr. Ramakrishna Reddy, United India. These are all more than 10 years old cases. We would not like to get it adjourned. United India.
Provided that it's
He is also handicapped. Date of accident is? Date of accident is?
So first of all, I'm in the library. On exaggeration is good. Date of accident,
19/1/2009, still older.
yes. 20 years old, but it's
22.
years, the student, not 15,000 students earnings.
Employed as?
Mother and father are the claimants, but now the
No, he was earning something.
15,000 by way of tuitions, that's only, it's not.
How much has been assessed? He was pursuing his final year as engineering student.
That's the case of like 12,000 students. Engineering student, Ramalama versus Venkatesh pursuing a level. There is usage rate of this food merit that fixed is 15,000. Food merit subject to deduction of 10%. Because each year, if you come to a graduate who completed engineering merit, it's 12,000. It's not
He was final year student.
Yes.
Tribunal has assessed 10,000. That will take it to 12,000.
There's another 40% taken from benefits. Yes.
12,000 per annum.
Yes, 12,000 minus 12.
12,000 per month. No.
Yeah, 12,000 per month minus 12. Because 10%, because if he's a 5 years student, 10% is put in. Graduate who completed engineering, it's 12,000.
12,000.
12,000. So 10,800.
10,800.
10,800. $4,320 future profits.
4,320. 40%.
40%. 15,120. SLC is a bachelor, it's 50% post master. $7,560 into 12 into 18 million.
15,120 into 12.
7,000
7,560 into 12.
15,120,
Because since bachelor minor contribution to the family is 50%.
50%. That will be
That comes to 7,560.
7560
Yes,
into 12
yes. 16 lakhs, 32,960.
into 17.
18.
18.
24, yes, 18 crores. Plus 88,000 to the parents.
This comes to 16 lakhs
32,960. Plus another 88,000 to the parents.
88,
Plus 33,000 towards loss of estate, funeral expenses.
33. $17 lakhs 53,960.
Yes.
As against 2.6 lakhs. No, there's some clerical error there that has been. If you look at internal page, the page 12 of the appeal, internal page 8. The first top paragraph.
Yes. Happiness as a sport assumes that person or intake of 13 license. But it's themselves because the claim itself is claimed for Lingamas case comes. Yes, sir.
That should not have been there.
Yes.
The present is an appeal. Last name for the previous class. Who are taking the this? Who are taking 7? Last name paragraph, so far as fees is concerned, that will be same. This you circulate it among themselves, that fees part will be the company. And what together we will be consideration.
Yes.
Yes, who's there? Yes, we have a sitting there also. Presentation appeal which has come before this court for confirmation of the order. In the award passed in the Lok Adalat held on 12/3/2022. On due consideration, we confirm the award. But
My question for 2 weeks. 53.
33.
Yes.
The request of counsel for the petitioner is this case on the 15th of December.
Item 29, representing Rajesh Reddy. They have 52.
Saying just write the name Miss So and so under instructions of Shri Rajeshwari. Listed on 15th of December. The earlier matter also take the name of the council. Just 1 second. Yes.
Item 37, 52. Item 53 to 67, item 62 and 63. I inform that.
You are for the petitioner,
Yes, ma'am.
62 and 63.
Yes. BJP product.
Who's on the other side?
Mala.
You inform Shri Malla Rao.
Yes, sir.
Sure.
Yes.
We are extending the interim. Tomorrow you should not come in. 62 and 63 at the request of the council for the petitioner. This case on the 22nd of December. Yes.
Item number 57.
57.
Representing week of our township. The interim order is extended.
You are appealing for the petitioner.
Yes, inform that.
Who's there? Whom did you employ? Whom did you instruct? The other side. Inform. So the other day there was some other council who came in a similar matter. He said that we were not informed. And the other side, you informed.
Yes, ma'am.
57 at the request of Ms. So and so under instructions of Shri B. Gopal. This case on the 22nd of December. The interim is earlier granted. 62 and 63 also. You have an interim in your case also.
Yes, sir.
Yes.
Item 68, page 2.
22nd December.
Item 68, page 2. Item 83.
81 manner, there is directive for 4 kilometers as the character matter, but they are not posted today. They are posted those three.
In this case only,
This is what the common order. Those matters, next,
81.
81. The district matter, because the order they are and they are posted today. And they are second.
We had already ordered for connecting matters.
It's posted today, but they are posted only one matter.
You have the numbers connected.
Posted 03 of 3.
Only one?
Yeah, one matter.
27.
03.
27. Previous year, we have directed, this could have directed the CRP to be listed along with 2703.
District matter, they are
CRP is not listed. Is this case on the
district matter. They are district matter.
17th of November? Yes.
Item number 84. 84.
Yes.
Rohit. 87,
87, 88 and 89. Those would go along with that.
Same date, the 24 week for
This, we have it a week after next.
Yes, ma'am.
87, 88 and 89, this is case on the 24th of November.
Of this.
Yes.
84 you are.
84.
Yes.
You are appearing for
Petitioner.
petitioner. Who's on the other side? Shri P. Durga Prasad.
Yes.
You have informed.
Yes. I have met, I have not informed, I met, I told you.
Meeting and informing are two different things.
Yes.
You have an interim in your favor.
No.
No. Then you take as much time as you want. 84
Item number
I request of the petitioner in this case on the 22nd of December.
83, my lord.
Yes.
Member petition. Extension of petition order to not make anything, grant 2 weeks time. I should also notice as directed by the Supreme Court. The candidate 2 weeks time.
Proof of service?
And for petition.
No, proof of service?
Yes,
You filed it?
Is also filed.
83, this case on the 15th of December. Anybody's entered appearance? It will be early granted to continue. Yes. 15th of December. Yes, extended.
So then, I can make it.
86.
You could break up after breakfast in the afternoon. 56.
We don't know. I mean, actually, there is a special bench there in the second half.
After that, breakfast.
If time permits, yes. If we are assembling.
If you are not paid, but I don't think there.
Otherwise, we'll have it next Friday.
Yeah.
We will see if we are reassembling after the second special bench, then we'll come back. Yes, 86. If we assemble, take it up at 4:15. If we are reassembling, we'll have it at 4:15.
Yes, sir.
Yes. Thank you.
90.
So,
Yes, there is some output. Yes. Withdrawal.
Yes, I for the council. Two CRPs, one is for CRP number 142, and the other CRP for 290. The matter settle after the court. So anyone next one can get.
Take it up next Friday. Next Friday. For withdrawal.
Item number 19, petitioner request to 1 week time. Percent and
What is this that you have done?
so, registry has raised some objections. Maybe it is maintained an option.
Then
Or is it to direct or numbered or rejected?
usually these things can you want time.
1 week time.
It's going so under instructions. You are appearing under instructions of
Just inform the petitioner council 1 week time.
you were instructed by Sri Suresh Sagar.
This
She showing you under instructions Sri SS Sagar. It is for time as per for time. This is on the 8th of December. 8th of none for the applicant is this case next week, 10th of this November.
will be permitted to record the CRP.
Council for the petitioner case for withdrawal of the CRP as paid for the CRP stand dismisses withdrawn. Yes.
Like,
22, Damodar Gupta.
yes, we do. This matter I am the petitioner. Item 24, 23 shows similar results. There are two suits wherein 2 EPs were filed against the common respondent. Suits for EP was filed, notice is ordered to us. Within 2 years, notice need not be ordered because statute is very clear on that particular aspect. A suit for rejectment, when more than 6 lakhs in each case are due and payable with the date of filing of suit. Another 6 lakhs are right, means totally 24 lakhs are due and payable as on date.
and he is keeping the premises closed, not delivering possession. Even they have caused their appearance in the lower court, but did not file written statement. Subsequently, ex parte, the 15th petition was also filed. Did not deposit the rest. And thereafter, ex parte was recorded in Suba's degree. And now, when the EP is filed, the court again orders notice to. I have filed the citations also regards in the paper. Page number 12, wherein the court clearly says. So, Bombay report and another one is an unpublished report, wherein it's clearly stated that within 2 years, no need of notice. Straight away warrant has to be issued. Towards page number 13, by people. Under order 21 to 22 CPC, when an application for execution of decree is made after expiry of 2 years from the date of decree, then only the executing court is required to issue a notice to the judgment data for requiring him to show cause as to why the decree should not be executed against him and otherwise not. In other words, when the execution is not.
Where are you reading?
I'm reading first, the second one, on page number 13. 13. Under order 21 to 22, when an application for execution of decree is made after 2 years from the date of decree, then only the execution court is required to issue a notice to the judgment data for requiring him to show cause as to why the decree should not be executed against him and otherwise not. In other words, when the execution is sought before expiry of period of 2 years from the date of the decree, a reverse situation would be true, thereby meaning that no mandatory duty would be cast upon the court to issue a show cause notice to the judgment data. It would also mean that the executing court would not have the power to execute the decree forthwith without issuing any notice to the judgment data. There is no provision in order 21 to 22 conferring any discretionary power upon the executing court to issue a show cause notice to the judgment data, even in a case where the execution is sought within 2 years from the date of the decree. So this is what my contention was before the lower court also. But lower court orders notice. Is not appearing before the court, not paying rents in June 2020. We are in 23 now, almost 4 years.
The docket order is dated
5/10/2023. Page number 4.
and the date given by in the notice is
13.
13/11. Which now has been declared a holiday.
Yes.
He gets another escape.
Yes, definitely, because he's keeping the premises lock and key. Because now nobody is residing that, but he's not delivering his possession.
Difficulty is how do we allow the CRP expert?
So with this particular aspect is where there is a mandatory provision. Order 22 would go.
Now the notice issued, has it been served upon him or not?
In the lower street was served.
The EP.
He caused.
No.
In EP it has not been. Because when I find EP, this notice was ordered against which I am finding the present revision before the court. In suit, he was duly served. Advocate was appointed. He caused his appearance also. Did not pay the rent. 15A petition was filed. When he has not paid, he was set expert. Trying to file a statement was before he exam. Thereafter, even he filed an application, but thereafter did not appear. He has prolonged the matter for more than 3 years as a
Application for
setting aside expiry of
which was not pursued.
which was not pursued subsequently. Because the council says the party is not coming. That is what his representation in the lower court was. So, however, all these things have happened. A decree was passed. That giving him 3 months time for delivering possession. Even
We find force in your submission, but the question is how do we allow the petition expert? Because it would be literally allowing the petition.
yes, that is
That
the fact remains that the decree before the Honorable Court is page number 8, which starts at end at page number 10, wherein he has been granted 3 months time for delivery of possession.
we don't dispute or doubt what you are contending. The question, the apprehension that I have in my mind is how do we allow the 227 petition ex parte?
statute is very clear.
That's different thing, even for that. Because it is the first order in the docket which is under challenge.
Because
Suppose if he enters appearance on the first date, 13/11 or whatever is the next date of hearing, and maybe concedes or accepts the order, your grievance would stand redressed. If it's only in the event if there is any prolonged litigation at his behalf, at his behest, only then would.
I filed this particular suit in 21, wherein in
What we'll do
21.
is we'll issue notice here
That's again,
and see what would be the reaction in between by him before the court below. So that if he enters appearance over here, we can dispose it off.
not in these circumstances, because I'm just persuading the person to put that since there is a degree, there need not be any notice. That is my contention as per.
No, rightly or wrongly, the notice has been issued.
Yes, yes, that is a.
The next date is 13/11.
Yes.
Today we have 10/11, just 3 days away. And if we accede to your prayer, which we are finding sufficient force, the only thing that is coming in the way is, can an ex parte order be passed allowing a petition? To that extent, how far will it be justified? Ex parte allowing a petition. And that too at the admission stage.
Because the order is against the statute, wherein statute does not permit the court to order notice if the execution petition is filed within 2 weeks. That is my contention before the Honorable.
No, perhaps the intention of the court is the moment he enters appearance, there will be direction given that he should ensure that he should vacate the premises within 24 hours, 48 hours, 72 hours, whatever it is. That perhaps is the mind of the judicial officer.
I'll come the other way, because he has caused his appearance of the service of notice
No.
through counsel. 3 months time was granted at the passing of the decree. It's not that 1 month or 2 months it was given.
All that has already happened.
Yes,
He has not resorted to any other legal remedies
it's
available.
not that he is not put on notice in the suit,
We don't know whether he is aware of that ex parte decree passed.
because he has caused appearance and the council's name is appearing in the decree.
He'll engage the new counsel in a fresh CRP before this court, and he will claim that the other counsel has not intimated the ex parte proceedings and he has not carefully attended to it.
Have to be due
This is-
diligent in
This is
in a suit for
usually that we are facing.
From 2020, we are in 23 now. Suit was filed in 21. It is not that he is not put on notice in the court below and that straight away ex parte decree has been passed.
For the initial 2 years, 2020, 2021, they have a safest of excuse of COVID pandemic.
Yes, I would definitely agree, consider it, because even granting of 3 months, I have considered it. Because 3 months time was granted, it's not 1 month or 2 months after passing of the decree. Even then, he is not vacating and delivering possession. Order of notice, which is against the statute, when the EP is within 2 years. That's what.
Take personal notice, we'll take it up after 2 weeks, personal notice. See, allowing it at this stage in limine,
You'll have to post it next.
that would amount to, he has the best ground to challenge before the higher court.
Because he is keeping the premises close to 24-25 lakhs rents are due and payable as on date also. Even then, because it is not that he is not put on notice at every stage. Before issuance of, before filing of the suit, ejectment notices.
That's what I said, take personal notice, we will take it up on any given date by you.
They posted next Friday first. I think.
24th we will have it. 10 days time we will get. Let personal notice be effected upon the respondents and the matter be taken up for hearing on the 24th of November.
I may take up notice to publication because definitely he will not take notice. Premises is in under pocket.
In addition, but that publication also cannot be permitted at the first instance unless it would project as if the court was also in a haste to.
Because activates the premises in locking on date. So that is what it is. Two matters would go.
Yes, 22, 23, same order.
Article 4.
I entered my appearance for respondent number 1, which I am ready.
Who for the petitioner side?
Petitioner. Right of filing the administration was forfeited by the tribunal, your lordship. That the order is on page 8, your lordship. The operating portion is page 11, your lordship. My claim number is the plaintiff who filed the suit was number so against the defendant for the specific performance in the year 2013 OS number so and so. Subsequently, it was renumbered as the OS number so and so. Defendant right to file the written statement is forfeited by the court on 16/3/2017. But the petitioner defendant number 2 filed the present petition as to set aside.
Which is the order under challenge here?
Yes, your lordship.
The order under challenge is page 8.
Yes, IA only. Your lordship.
That's an order dated 26/7/2022.
Yes, your lordship.
The instant petition is being filed in October 2023.
Yes, your lordship.
Why after 15 months?
There is a delay, your lordship, for filing because that communication gap from tribunal to was few days.
You were aware of the development before the tribunal.
Yes, sir.
Then, and if you take 15 months for the filing of a petition, how far would it be justified?
There is a part delay, but actually it is a question of
Not
the value
exercise.
of property, your lordship.
We would not
Certainly
exercise.
It is admittedly of property, your lordship.
Maybe if you do not show due diligence on your part, particularly since you have been represented. Sorry.
It's not they are paralyzing, but in the case of the Supreme Court, your lordship, they are allowed the. Yes. May I just give you dates? In the civil appeal. In civil appeal number 6304 of 2021, lordship, and their lordship is in the page. Page 2 is the operative portion, you see, consequently the appeal is allowed and the matter is remanded back to the trial court to decide the suit on the merit after taking into the consideration written statement already filed by the defendant appellant as well as. Your lordship, that along with the petition, we have filed the
Here, nothing has been discussed. It is only.
Your lordship, this is the actually another cases also the Supreme Court has said that written statement is a valuable right. It cannot be.
But if you want,
Directory, not mandatory. It is up to the court to extend the time or the grant the relief, your lordship.
correct. But look at the time spent in between. What prevented you from availing the said benefit earlier?
That is the
Prevented you.
I am not
So
denying
you-
that it is the delay is there. But only thing is that your lordship, this valuable.
Wide open eyes.
Huge properties are involved in this case. In Telangana, about 87,000 bucks are there, your lordship. In this case, that is the files daily in tribunal daily about 50 cases.
That should not be a ground for permitting the work board to take things for granted.
But this may get few days.
Just wait. One could have understood if you were an individual. If you were a stray or a rustic villager, this ground that you are advancing would have been quite convincing. But then look at the petitioner, work board.
Your lordship, that is, this matter is not now, it is a pending since 1975.
Maybe.
Because it is there, They are trying to alienate the work property, your lordship. So now we have saved the work property by.
It is not the very only case that I have come across in the short span of time. Every week there is one or two matters from the work board in the same nature. For years together they would not act, and suddenly they become wiser, and then they put so much of pressure for taking up that matter and for recalling of the order passed by the court below. And at times we feel that these are all deliberate.
It's not deliberate, your lordship. That's we are.
Not deliberate on your part. Deliberate on the part of the concerned official. You were heading the institution then.
Because the property is not in the plaintiff side, it is in this receiver, your lordship. That at least we are protected the property till now, your lordship.
Yes, what were you saying?
The suit was filed on 1/1/2013.
Yes.
The right to file written statement was forfeited on 16/3/2017.
Yes.
Well, it's the petitioner before your lordship cross-examined my witness on 5/5/2022. Thereafter, the present IA was filed on 24/6/22. I filed my counter. Thereafter, IA was dismissed on 26/7/2022. Plus, they obtained the CA and was issued on 29/7/22. Now, after 15 months, the present CRP is filed on 31/10/2023.
CC was obtained on
29/7/22. When it's 31/10, they filed the CRP. After the judgment was reserved on 5/10/2023 for the second time. Firstly, it was reserved on 7/12/2022. Due to the retirement of the judicial officer, again the matter was reopened third. And for the second time, it was reserved recently on 5/10/2023. And there is a government.
earlier it was reserved on
7/12/2022. Plus the which is argued that it is a work property. There is a government order permitting the same.
No, we are not entering into the merits. We are not entering into the merits. The only question is the rejection of the.
After matter is reserved for judgment, Phillips, such application itself cannot be allowed. Is my respectful submission. I am relying on 3 judgments. Your lordship permits.
IA was filed on
24/6/2022.
that is before it was reserved on the previous occasion.
Yes. He participated in the proceedings. He cross-examined the witness. Thereafter, the demnor may be seen. After 15 months, they come up with this application.
That's all.
Your lordship, this is the question of the saving the work property. Even government cannot allot any property except the work board. They have not taken any permission from the work board and they are entered with the mutavalli.
What was the work board doing for all these periods when they were participating in the proceedings?
It is true, your lordship, but it is part of the failure on part of my colleagues.
You are-
I'm not saying that it is not, but it will be allowed on the payment of some cost, your lordship. Otherwise, I will be permitted to file the more
law commission reports and other things, because it is not mandatory, your lordship, it is directory only. The provision for the filing in 120 days.
Challenge in the present petition is to the order dated Yes.
Correct.
That's your four methods are there. Four methods are erasing out of same OSP. This is got two more CRP SRs are in pipeline, but they're in the SR stage actually. These four and two stone have maybe taken up next year.
This is item number
IISR number
25.
item number 25, 20 also. Four methods are there. Four methods are
We
there.
got you. 20 we have already adjourned.
Yeah.
Adjourn for next week.
This also.
25 list
Two more
this case.
CRPs are there. But
25
total
list
four.
this. 25 list this case along with CRP 3238 of 2023. Yes.
The 3302 and 3303 also are there.
CRP.
Today.
Serial number
This is
32.
3202, 3302, 3303, 3261, 3238. 4 minutes.
Just give us the number.
Yeah, yes, yes,
Give us the number. It will all go together.
yes, ma'am. Yes, I see. Unfortunately, today actually the other CRPs 5 were supposed to be listed and the lordships were placed to direct to list them on top. But it was not listed today. Yeah, why today again.
We got it for listing it today.
Usually for 13th for other sections.
You come up to one.
Question for other sections. This was day actually there.
To your advantage, it didn't come up today. Because second half, we have again going in for a division bench matter, your matter would not have reached.
But we are not waiting actually. For others to caption, they posted it for perhaps others captions. Limited step, we may take it at 2:30 minutes.
No, 2:30, there is another bench.
Bench limited for step.
We'll have it next Friday.
Till then,
Nothing is going-
dispose of the matter and
Nothing is going to happen.
let's.
Lord, may I please, your lordships? I may be permitted to represent in a hybrid mode, my lord.
Third of August.
The revision is filed, my lord, questioning the order passed court below.
There is the caveators have entered appearance. You say that they have not been served with the copy.
Just now I received.
Lord, I served the copy.
Just now, when after the number is called. Next Friday.
My lord, one thing, my lord, they filed a order 15A2 application, which is listed on 13th, my lord, 13th of this month.
Which has been declared a holiday, nothing to worry.
My lord, on 14th it will come, my lord.
Formal.
My lord, till then, my lord, my
Friday.
request should not be striked off.
Next Friday. List this case next Friday.
The present CRP is filed against the inaction of the Honorable Trial Court in not issuing the certified copy of judgment and decree in OS number 141 of 2015, Your Lordship, on the file of 27th ACJ Secunderabad. The judgment was pronounced on 21/7/2023, Your Lordship. That was the date of pronouncement of judgment. And till today, I have not got the certified copy, Your Lordship. I have
When
tried
did you apply?
I apply on 25/7, Your Lordship. And I have made multiple representations before the court, Your Lordship. Apart from that, I have filed one IA also before the Honorable Court, bearing number 1679 of 2023, seeking stay for a period of 4 months, Your Lordship, seeking extension of period of vacation of suit schedule premises. Because the important point is, Your Lordship, the judgment, kindly see the docket order, which is on page number 7, Your Lordship. It says that
Why should it take so long a period in the civil court for providing certificates?
that's what, Your Lordship. Every day I'm making oral representation, Your Lordship. And the court is saying 2 days, 2 days, 2 days. That is what, that kind of response I'm getting, Your Lordship.
In fact, yesterday also I come across in water. They took 8 months time for the case. Because my people are asking, is there any remedy to do this before the High Court? That's what they ask.
Your Lordship, the most significant part of the docket order is, it says that I need to vacate the suit scheduled premises within 4 months from the date of pronouncement of judgment. And already 3 months, 20 days have expired, Your Lordship. What about my right of appeal, Your Lordship? It would be rendered fruitless, Your Lordship. Once he gets possession, I'll be left without the remedy.
The judgment was pronounced on 21/7.
Yes, Your Lordship. 21/7/2023. I applied for CA on 25/7, Your Lordship. And since then, every alternate day, I'm making representation before the honorable trial.
The officer,
27 ACJ, Your Lordship, Srimati Ratna Padmavati. Because the period of vacation is nearing, Your Lordship. And I'm getting phone calls to vacate the premises on everyday basis, Your Lordship.
the present CRP has been filed.
Direction may be issued to the trial court to issue the certified copy. The stay may be granted, Your Lordship, by extending the period of vacation of such scheduled premises by 4 months from the date of release of certified copy.
The instant CRP has been filed seeking for a direction to the trial
80
Yes,
states can join.
80
80.
extension of state. Yes. Who's on the other side?
Who is appearing on
No one is appearing. 80 is late.
that?
Item 3 last.
8th of December.
31, item 31. The
Yes.
respondent has filed caveat. I have served the copy just now, my lordship. It will be posted for next week.
31.
31.
Who's appearing for the caveator?
Petitioner. And, she is,
Caveator. We'll have it on 24th.
yes, ma'am.
24th.
Item number 36.
Similar case, not caveat is there on the other side and the petitioner.
I have not received the paper.
Either number,
36.
same order. 24th.
First December.
1st December.
Yes.
Yeah.
That's item 86.
First December.
Maybe for hearing, finding a counter and hearing, I just want to have a counter and have a hearing on that thing.
They have to solve the papers first.
Serve a copy.
I'll serve.
We'll have it on 36. Yes.
Item 85, item 39, which is
Yes.
a matter where control delay was dismissed, may be permitted to serve personal notice. In any case, notice will have to be ordered.
Issue notice. Was this case on the 22nd December?
Very good.
22nd December. Personal service. Personal notice is also permitted.
Item 85.
Yes.
Unless it's coming for extension, my lords. If pending the matter will reach, I have not informed the other side. If she may have it next week, my lords.
How are you so confident?
My lords,
With today's cause list,
I cannot see that 2:30, that, yes, my lords.
when do we have it?
Next time. Because
Who's on the other side? Who's on the other side? Who's on the other side? It will be your responsibility to intimate him. 24th November. What is the urgency?
The CRP 24, the respondent has vacated the premises. The motion for the orders to be on the CRP also.
What is left now?
Because he's going to MLP written statement and a conflict with the lordship. It's posted on 16th of next week. That's posted on next week.
Before the court below.
This is lordship. So we posted for next week lordship.
17.
So item number 79, the interim orders are going to expect today in lordship.
Item number
79.
79, the interim order earlier granted to. Who's on the other side?
First side is none of your lordship.
Not of you.
Meaning that the disputes may be out of.
This is awaiting the service of the respondent. Place this case on the 15th of December. The interim relief earlier granted to continue.
It is number 50 lakh, 50.
50.
The stay is expiring today. The
Same
other
order.
side is requested myself only to do that. Other side is not.
So you are appearing for both.
I'm the petitioner, but the respondent is not well. I'm the petitioner.
Council for the petition, the request of the council for the petition is this case on the 22nd of December. Yes.
Same as
Item 22 and 23, which I argued matter has been posted on 17. I would request the court to take it up on 17 without ordering any notice, so that I can certify the court under 227. It is permitted. Which the court can pass orders, allow CRP under 227 without issuing notice to respond. Also,
Not in the given factual circumstances. We don't say that we don't, I just disposed of one petition. It doesn't mean that we don't, in the given circumstances. For that, we'll have to hold that the action was per se bad. That,
in that circumstance, I would have taken notice in the lower court itself and I have gone with the EP.
that is what I said. 13th is the date given by the court below. Today is 10th. Maybe they must have entered appearance. They might enter appearance. We don't know.
Loss of function.
Yes.
He requested 3 weeks time loss.
We are giving it on 22nd of December.
Much of
22nd December. Yes, Mr. Council.
site, so.
Writ appeal by the state government, writ appeal number 955 of 2023 stands allowed. Writ appeal number 866 filed by 866 of 23 stands dismissed.
Okay.
One of seven. Plus 40% will include. Petition dismissed. Not state improvement. The other, the Praveen what we manage.
The two petitions stand dismissed.
Right.
One time, I go pass over the revenue.
Okay. Things that take time.
Only on the ground that they have filed a better affidavit explaining the delay. Broad state, consider it's big, then. What is that? The main repetition is that the review model was beyond limitation, my lord, that's not good.
Delay in approach to expert. 2 years, just taken, the history has taken, the approach is good.
You have the records of the repetition? WP USR 57789. The date of the impugned order is
8/10/2020.
was not available on record then.
My lord,
Better affidavit was not there on record then.
but was not ever, my lord, they in fact, the date, but yes, argued the case only after.
Not there.
Yes, ma'am. After considering his submissions only, that order was passed.
Well, because we have made a specific observation that the better
Yes, ma'am.
affidavit seems to have
Yes,
not been
ma'am.
filed.
That's the order.
And neither did he point it out that it has been filed.
No.
In that context, we'll have to allow the
My lord, the review might be allowed, ma'am. The main reputation might be posted for some.
instant review petition has been filed seeking review of the order passed by
Mistake may be posted, my lord. It seems to be even this, implement the order is barred by linkage. Assessment area is 2013-14 and the order is 2020. I don't think.
One and second, it was during COVID period. Yes, we have, so why not we allow it today itself?
I'll check my lord. This file is.
The bench again would be difficult.
My lord, this case may be released, my lord. This review.
Well, that's a different thing. Then. We can definitely.
On those dates may be posted.
Let the petition itself be listed for further.
Yes, that's fine. Okay.
But for example, the review petitioner, my senior is traveling. She's away and she's in transit. So she's unable to argue the matter fully. Taking 1 week's time.
With great difficulty, the benches are constituted. In any case, it would have to be heard by this bench only.
It only saying an alternate remedy may be available. That's the order. The review is further.
Usually has been taken that one judgment was placed on it, subsequently it was not able to.
That by itself would not be a ground for, but in any case, we.
Unmixed time question.
See, so and so entering appearance. Who's on the other side?
Because it reached about 425. Yes, that's it.
Who's appearing for the respondent?
How many, so 80 pages,
Like all of them, because below my limit, we are withdrawn. It's only above my.
but it is needless, the grounds, in the narration,
Yes,
starts of page 2 up to 79, 38.
but operative portion of it, it's.
7 days for 3 questions.
Yes.
4 questions.
Yes.
But the background is to read. Valuing the content.
Yes, that's the reason, and the 4 days also have only one bundle on that day. Information.
And then this doesn't, in fact, it's referred to the final order was not on. Everything is there. Except the grounds, nothing is there.
The day because they quite one.
Right.
Compared to marks, almost. Only one set is there.
One set is there.
Yes, one set is there. That's the reason. He said he will be publishing because his scanned copies are there. He will publish.
You have not. But in the
Going to the entire, because the department has taken all pains for it, it's except after 80 witnesses, but it's something fishy, that's only after going through the order. And the entire fines were reduced to 5 lakhs, reduced to 5,000 slide by what can you see in the order that you find it a final order.
I think there are 3 bundles.
Yes.
One is this original grounds and
Yes.
I think one more bundle is with regard to original order and include the final order, original order, the short term. So, I think one more is with regard to the judgment cited by the appellate.
But in fact, with this only period, we have to start the judgments period. That judgment will find your worship. The page number. Page number is also not there. It's the all. Even page number 11 of the order, my lord, that's sister order. Page number 11 of the sister order, my lord, it's
The absence of the respondents, how do we have final hearing?
release it in the first for rendering and some other day.
Matter of 2006.
Yes.
It is released from the part of.
My lordships.
Yes.
So, as I have discussed yesterday, also my senior is having a throttle infection. So we would request you to extend some time.
When?
2 weeks time may be given, my lordship.
This order to be released from the part of. That also clear. Previous one also 29.
I'm not to 39.
29. Yes, 29.
Lord's permission.
Yes.
On item number 85, it appears the FSA has made a mention, Lord, where the executive order was to expire today without not informing me. Though I filed counter, served them in 2 days in advance.
Yes, some date is given in that.
They don't inform me about this. They sent a message, they deleted again. I don't know why. Now they sent a message saying that we are representative for the court. And now again they deleted. That's why I got it out.
This is what happens when we take up the matters at.
Next.
We had also accepted to his request was because we were not likely to come back again as single bench. But because a few matters got adjourned, some date has been given, you are aware of the date?
That's what he informed me of. He sent a message and again he deleted. That's why I got it out. Whether it is confirmed or not. 24. Because 2 days advance I served copy of the counter because I'm opposing it seriously. Right.
Yes, 75 and 76 Lord. Other side does not appear. It's fine. Today, Lord, in case it was not reached.
Yes, 75, 76. In case if it doesn't reach, it will be extended. Just note it.
Please, Lord. Lord, petitioner for your lordship, my lord, JDR is an execution petition filed by the bank for recovery of money, my lord. For execution, my lord, what was presented was an award passed by a unilaterally appointed arbitrator in Delhi. My lord, the counter was filed opposing the execution petition, my lord, and it was also raised, my lord, that the award itself is ipso facto illegal and null and void because no notice was issued to us and it is passed by an arbitrator who was unilaterally appointed, which is in violation of the full bench judgment of the Supreme Court. Not considering the same, Lord, the EP was allowed, my Lord, mobiles were ordered to be attached. The only question of law that I am raising here is not whether the executing court was bound to look into this legal aspect as to whether when an award is ipso facto illegal, can that be considered by the executing court? My Lord, I am supported by a few judgments. If your lordship permits, my Lord, I will just rely my.
What have you done to challenge the original?
I have a 34 application before the Delhi court, my Lord, it is pending.
Have you pressed for an interim?
No, we have pressed, my Lord, but there is no presiding officer as such, we have not got the stay, my Lord.
If you have not pressed it,
well, we have pressed, Lord, because of the absence of the presiding officer, my Lord, we should not get the stay. But the question of law that I am raising here is, would the executing court also has to look at
that would be easily answering to your appeal which you have filed there.
I have got a good ground there also, my Lord, and the same.
Will it not amount to agitating it before two forums?
I do understand, but I am supported by law.
Maybe yes. You had an option of either. You cannot avail the remedy of both.
For the purpose of EP, which cannot proceed on the basis of an illegal award.
What happens to the appeal?
Appeal certainly will be
by influx of time, by consequence, it becomes renders infructuous.
No, but it will not render infructuous because ultimately it has to be set aside.
If your objection is sustained in the EP, then
EP proceeding will be stayed till the appeal is not decided.
So that is what you have to pray for an interim in that application.
We have taken steps, Lord, but at the same time, because of the absence, we are just relying on the judgment that I have brought before your lordship, Lord.
That will be difficult at this juncture.
Just do my duty, Lord, and leave it to your lordship's kind consideration. But there is a division bench judgment, there is a full bench Supreme Court judgment, and a single judge for you.
We don't say that you don't have a strong. The only case is you have chosen an option of appeal that is already pending.
Lord, that am subject to correction in my understanding, Lord, that may not amount to waiver of my right to raise the very same plea before the appellate court, Lord, in Delhi. Because here the execution.
That you have already raised.
That I have already raised.
That you have already raised.
Yes. And in termination, in EP proceedings, also for the purpose of termination, Lord, I have got a right to raise the same plea. Because if I do not raise the same plea in the EP, Lord, again it will go against me as per law. And the lordship also sees the award for a moment a small claim. It is in the core COVID period, that is on 12th October 2020. I am conscious of my limitations. I am conscious of my limitations. At least we are subject to payment of 30%.
Far more, we have got more limitations as compared to your limitations.
Subject to payment of 30%.
We are under 227. It's difficult, it's not, even if it had been a 226 petition, there could have been something more that we can travel.
115.
The same thing, supervisory jurisdiction.
Take to payment of 30-40%, 50% of lordship may, because there are good chances for me to succeed not to the appellate court. Otherwise, everything will become infectious. But do not entitled to raise this ground. I have not even subscribed to it.
Better press it in that application.
Plus,
Your 34 is pending.
34 is pending.
So press an application there itself. Non-availability of the presiding judge would not come in the way because it would always get marked to another bench.
What is happening in
It is not that court would lie vacant.
That is true.
So having already availed the remedy of 34, simultaneously under 115, same ground being considered would be the same ground being agitated before two forums. Same very same ground.
But that is touching the roots of the case.
That is what is primarily available with you under 34,
Yes.
which you have availed.
Yes, I am aware. Take to payment of
Therefore,
50%.
115 would be difficult to be entertained.
Take to payment of 50%.
Because the finding in this would have an adverse bearing on that.
That is true, but on the face of the record, if your lordship says it's a unilaterally appointed arbitrator and he is referring to nothing with regard to compliance with section 11. On the face of the record, your lordship says it's an illegal award. And during the COVID period, October 2020, there was no opportunity also for me to appear before him and to take any steps. Had the notice been issued, my case is that even no notice was issued to me while the award was being passed or it was initiated.
Even if it had been issued that time, you would not have traveled.
You could not have traveled. The notice could not have been served upon me during that period. Because everything had come to a standstill.
Why don't you press 34? What difficulty is that?
We are taking steps, Lord. My counterpart is informing that they are pressing for the council there to take steps, but
that is what you say. That does not permit you to avail the other remedies then.
The point of law, as a lordship knows, can be addressed anytime at any point. What it be
not simultaneously before every forum that is available with you.
But if I had not raised here, that would amount to waiver. They would
Just like reluctance of this court, then you go to another forum, file another petition 226, simultaneously go under 32 before.
Had I not taken that ground in this division, they would have taken that ground saying that I have waived my right to take this ground because I have not raised it in.
No, this is EP, that is the original appeal. That is the first remedy that you have.
Understand, Lord, totally I've got only one ground with regard to looking into the illegality of the award, subject to payment of 50% if your lordship has no case.
That is entertaining it on merits. And don't say that you don't have a case. Question is when the 34 application is already pending. Simultaneously agitating the same ground in 115 in an EP proceeding, that too. The present is a
I will deposit the amount, my lord, subject to the result of the appeal. Your lordship may grant me 8 weeks time, my lord. That I think should be sufficient enough. My lord. Subject to the result of the appeal, I will deposit the amount before the court, my lord.
Question is, once when we hold that it would not be right on the part of this court in exercise the revisional powers. Because the matter already is sub judice before the TSHC court under 34.
Subject to the result of the appeal, I will deposit the amount that they are seeking. The bank is seeking 5 lakhs.
Why can't such a relief be sought before under your application under 34?
Your lordship also has got extreme powers to grant such a relief.
Simultaneously before 2 courts knocking the door.
Just requesting for 8 weeks time, I will deposit the money subject to the result of appeal.
Sorry, sir. Difficult. This is difficult.
So that if I succeed, I will be able to recover the amount.
I am reluctant to exercise the powers itself, the revisional powers itself. Though I am convinced with the submission that you make, but for the reason that you have already availed the remedy under 34, simultaneously under the revisional powers, exercising the stage powers would not be justified.
I leave it to you.
The CRP filed by the petitioner limited extent to elections, where in Dasna vacation where we have moved the suit to elections for taxation of not finding the certain values to award your elections between the defendants, and I have got orders which is page number 27 your election, receive and transmit application. Where in that your election, page number 30 release your election, in that granted order and posted to further next hearing date, till next date of hearing. That is 10/11/2023. When we have, it was numbered your election and the IA also argued your election lengthy, and yesterday your election, I have pressed to extend the purpose. Now, the learned presiding officer saying that it is only the Honorable High Court purview, it is not in the purview. She is going to pass orders within 1 week your elections in an IA for inaction. My client is your election in this IA. She is under impression that it is the purview of the Honorable High Court. Only receive and transmit is the end actual.
What are the facts?
Fact is that your election, the defendant responding for to your election hearing filed a suit for special performance, and police award was granted between them your election from the third respondent. Local award, which I have questioned in suit your election. Suit late there your election, I will see my prayers your elections. Late I have filed.
That is impermissible. How can you challenge an award passed in the Lok Adalat in a suit?
Yes, I'm not party, not pending. I'm seeking, not pending only, I'm seeking your election. My prayer question, page number 42, your election. If I am party, I can question it restriction. Only police who specify award your election. That's why. Because the police who local award so and so win your election. Registered sale did got by the, it's a compromise award, but court has executed the sale deed your election. By extending the.
But indirectly, what you intend to is challenge the award of the Lok Adalat.
Not binding on any decree your election, only award, even though it is award.
What is the award?
Award is for registration your election, specific convention agreement, execution of agreement, and registered date.
That has been acted upon.
Yes, your election.
Then
they have came to my princess your election. Then only find this suit your election, seeking that it is not binding.
No, but then you will have to challenge it in a writ petition, not in a civil suit.
Not your election. If I party, I can challenge the writ petition. If I am not party, it is only the remedy for only the third parties.
No, even if you are not a party, the fact that you are challenging an award passed by the Lok Adalat.
Yes.
The remedy would be only 226.
No. If party is there, quality is the protected. As per our honorable, like right now, I am not having to. Otherwise, I will draft the election. It is there, your Lordship. If I have 40, I can question in 226. If I have not 40, I can remedy for separate suit for declaration. Now I am seeking for declaration by way of the attached position, your Lordship. And if those decree is not binding, award is not binding, and that is only my belief. Now my belief, your Lordship, what is saying that this order, may I read your Lordship, page number 30, receive and transmit intermination protected your until today. There shall be an intermination restraining the response number 2, defendant number 2, from proceeding EP 12 of 2003 on the first senior civil civil code Hyderabad and interfering with position of the fiction plaintiff over social property till the state of care.
Where are you reading page?
Page number 30, your Lordship.
30.
30. 27 start to election. Receive and transmit of the sample to doctors to election. Justification, house motion to election. Anyhow, that IA also heard your election. Both said legally argued and heard. Seeking now limited extent that IA 1168 of 2023 has to dispose it, then only your election seeking your election. These are the presiding officer under the impression that it has to be the party of the armed group. Receive and transmit only their rights matter to you. Once receive pass after protected, lifted and transferred, and it was numbered.
It is pending.
Yes, your elections are. Yesterday, both parties argued your elections lengthily, and 9th your elections is coming for orders to election. 1 week it will come to election. They said within 1 week, 15 or 2 or 3 days, it is going to pass.
This receive and transmit petition is still pending.
It is not pending your election. It's a receive and transmit only for purpose of receive and send it for limited protected. But it call on by showing this to election.
No. What I'm asking is, will it not go before the same honorable judge?
No, you will receive and transmit only limited portion of your election. Received it. Now entire bundle has sent to the court below your election. Even the bundle is not there your election. Yesterday I have tried your election. We are not having that bundle. Why? Because our duty is there. It's not only limited purpose of your election. Yet there is no bundle. Also your election. By showing this last portion of the article, the impression that it is pending before the High Court.
No, because here it is said that post on 10/11.
That is, let me give my limited knowledge to election. There is no pending to election. It's said I have asserted 2 days before also your election.
How is it ordered that post on 10/11?
That is the election. That is only the small.
So in that case also, if that rectification has to be done, it has to be done by the same judge who has heard the matter previously.
But it is an relevant is the election.
If you go by the order, it says that post the matter on 10/11.
Yes.
And if that be so, that means that petition is still pending.
Yes,
And if you say yes, and if you say that it is not pending, it stands disposed of on the date when this order was passed on 26/10/2023. Then this would need to be rectified. If this has to be rectified, it goes before the same judge.
Actually, there is no any bundle. That is a problem. 2 days, 2 days I have to be election. There is no bundle in registry. That is they said.
So where has that gone?
It will go to the competent court, civil court, where I have filed. It's go to there.
So rectification of this order would be by the same honorable bench which had decided it.
That bundle is not at all here in your election. That is my case. Since 2 days I am working seriously your election. Bundle is not there. But only what your election said, right, you are pointing out. If it is any wrong mistake, it has to rectify by the same day.
Same bench.
Yes. But your election thing is there is no bundle. This one is limited.
If there is no bundle, how does this court exercise the jurisdiction for rectifying?
Only limited your election. It is posted for after some 15 or 17 your election. Only limited I am seeking your election. Already threat of eviction is there in the
What limited relief?
limited until disposal of 1168, otherwise you will have any 10 days or 2 weeks you will have.
That would be done by the honorable bench which had passed the order earlier, not by this court. That is precisely what I am trying to convince. There is an order passed on 26/10. That petition shows post on 10/11. Now, any further modification, clarification, or explanation to that order can be only by the same bench.
But without one, they will not put up or try to file that IA also. But without.
This also may go before the same bench, who can clarify his order passed on 26/10. Because any order now today would be clarifying the order passed by an order.
The submission of election. Receiver transmit is the end, even though it is order is for Kala pending is what it shows. Now I am seeking election 1168 is already heard by the honorable presiding officer to election. It is passing orders on 15 or 17 election. And disposal only I am seeking. I have narrated the election. They have gone and kept for orders and they should be.
Question is, how do I derive jurisdiction
Pending.
in the teeth of this order? Will it not amount to this clarification to that order? Do I have the power to clarify that order?
That's why you are not seeking clarity that after the election. Only pending.
It would need clarification because that very order shows post on 10/11. That's the difficulty.
Actually, since 2 days I have pursued elections for filing of the IA for what they were making. They are saying we are not having anybody where the question of posting. They stay also settle election.
No, you could have taken this file to the honorable bench, which had heard your matter, and got an order. The same, this very file itself, because it would amount to clarifying his own order, and which only he has got the power. Make a request before the same bench.
Take up warrant also if there will be the hands of the second respondent. The what the election said. These are so. Elections, there is no.
You have to make a request before the same bench. Still,
Well, otherwise the elections, this may be post along with that. This one Monday election.
Please, Your Lordship.
Yes, sir.
Simpliciter suit for injunction was filed before the trial court. The first stage of hearing, there were lengthy arguments that were advanced. Without noting any of my contentions, there is no ex parte ad interim injunction that was passed, and only an urgent notice was issued by the learned trial court. Whereas challenging that urgent notice are before Your Lordships, whereas the imputed order is at page number 12. At 13 is the operative portion. If I may read my words. This petitioner counsel present heard perused. Having heard the learned counsel for petitioner at length and having perused the documents filed herein, this court is of the considered opinion that the petitioner has neither made out any prima facie case nor any other grounds, nor could show urgency to dispense with the notice, and thereafter ministries. Hence, issue urgent notice to respondents and posted the matter to after 25 days. But the Honorable Court records that I have made submissions at length, but none of my submissions have been recorded. And as to how, if the Honorable Court had come to a conclusion that there is no prima facie case or balance of convenience, those issues have not been discussed. Whereas my difficulty is this: she's a lady who stays in Andhra Pradesh. Her property is here in Hyderabad. On and off, she keeps coming and visits the property. The persons interfering with the property are the ones who stay in the same colony. Now, when they know that the matter is filed and no orders are passed, in the meanwhile, if they enter into possession of the property, my matter itself will become infructuous, Your Lordships, and then I will have to fight a long battle of declaration and restoration of possession. Whereas my humble request before Your Lordships is
since how long are you residing in Andhra Pradesh?
She has been in Andhra Pradesh for
quite some time. Is that she has not been dispossessed of that property for so long? Nothing is going to happen in between 25 days.
All of this,
only because a suit has been filed, why do you apprehend that there will be a dispossession?
The difficulty is, I have purchased the property not even a month ago, matters.
Maybe.
Prior to that, Your Lordships, my predecessor in title, they are all family members. It was a self-acquired property of my predecessor in title. The other family members have filed a partition suit. Their partition suit has been dismissed, and the Honorable Court had specifically recorded that my predecessor in title is in possession of the property and enjoyment of the property, and he's the owner of the property.
Yes.
From them, I have gotten the property now. Now, those unsuccessful family members are.
If the court is of the view that it would be required a hearing of the other side while considering the injunction application, and as notice and given the date for after 3 weeks, it is not that it has been fixed after 3 months. 3 weeks. Third, it was taken up 25th. It is ordered to taken up next date, 23rd, 28th.
Yes. Until then,
can you call that order to be so unreasonable for the invoking of the 227 jurisdiction?
The Honorable Court specifically records that I had made submissions. The submissions have also not been recorded, Your Lordships. I'm only requesting.
All that the court was required to add one more line for deciding all these contingent. The presence of the other side is required. That is all what is lacking in this order, nothing else. That is all. How do we say that it is per se bad for invoking 227?
My difficulty is my matter will become infructuous in case I'm dispossessed. The whole subject matter of the list will be lost, Malas. That's my only request.
So, how do you say, what is your suit for?
It's suit for injunction, Your Lordships. It's a simpliciter suit for injunction against the respondents because they're interfering with my property. I filed police complaint also that they've been interfering with my property. Now, she's a lady who's traveling on and off from Andhra Pradesh to here. My only request is this, my lords. If my lords may only grant me a limited protection for about a week or 10 days.
For what?
From being dispossessed from the property, I'll issue notice, when the respondent comes before your lordships, my lords may delegate us back to the trial.
No, the court has itself fixed the matter for 28th of this very month itself. Not even we cannot even call it to be a date which has been given at a very long time.
In fact, if I may urge your lordships, this one point that there have been previous instances where urgent notices have been given by the learned trial courts and had posted the matters after a long time, like 3 weeks or 4 weeks. In 227,
Counsel, please explain. Under what circumstances can 227 be invoked? The law is so well set.
Yes.
Only because in an injunction application notice has been issued And a very short date has been given on the within 3 weeks time.
That's my.
How do we hold the action of the court below to be unreasonable?
Because there is enough window in between.
Only because you didn't get an order in your favor does not mean that the action of the authority is bad.
Well, if I may show the merits of the matter, your lordship says.
That's precisely what I'm saying. It is not a case where your application has been rejected.
Well,
it is only that the court felt that let notice be issued.
Well, it was a matter for ex parte injunction and issuance of urgent notice would amount to rejection of that.
Voiding of dispossession, you say that it is still in your possession.
Yes.
If it is still in possession, there are so many ways that you can ensure that the possession is protected.
That's why.
If you do not avail all those options available with you.
Well, it's up. When they have tried to interfere, day before yesterday, when a complaint was filed before the police authorities. Unless there is not much that she is able to do from where she is right now. I'm only requesting my lords that the lordships may protect me until then. And it's upon them.
If I would have been a counsel, I would have suggested her just take 2-3 weeks leave and come and reside in Hyderabad till 28th. Pursue the engine after, let the order be passed and then go back. But you cannot have the cake and eat it too.
No, the difficulty is it's too much of a power for her to withstand because they are locals there to stay in the same.
Say so. But then that is not a ground available under 227.
Well, it's rejection on issuance of urgent notice would itself amount to rejection of ex parte and interim injunction by the learned trial.
No, and that would be stretching it too far.
Well, it's challenging that.
The court wants to hear the other side also before passing an order. That does not mean that it is an outright refusal.
It would be a refusal of my ex parte and interim injunction is my humble submission.
Issue of civil consequence.
Let's only to request your lordship that if I am protected at least until next week.
I have difficulty so far as 227 is concerned. That is all. When can 227 be invoked?
Well, there have been a couple of instances previously, your lordships, where this honorable court has entertained identical situations and had directed for status quo to be maintained.
I'm sure you must have come across a series of decisions of the Honorable Supreme Court wherein it has been held that 227s are not to be lightly entertained.
Yes, madam.
Unless it is in excess of jurisdiction or per se without jurisdiction or blatantly contrary to law.
In my humble submission, your lordship,
your case where notice has been issued cannot be brought under any of those categories.
It's denial of an interim order and therefore.
It is not denial. It only says that they would require the hearing of the other side also before it is granted.
It's just that your lordship, the subject matter of the litigation will be lost in case I am dispossessed.
That is an apprehension. That is an apprehension.
It's an apprehension.
And in that case, every order of notice which has been issued in an injunction case would be subjected to 227. Seeking for a same relief of ad interim relief.
Well, if I may please make one submission, your lordships. I had to prove in an injunction suit before the learned trial court that I am in possession of the property, undisputed possession.
Counsel, injunction, all said and done, is a discretionary jurisdiction. The court would have to get convinced before passing an order. In this case, the court says, let notice be issued. We are taking up on an early date. 28th is the order. This very month.
Yes, ma'am. Well,
the date given also is not too long a date so as to presume that in between something substantial could happen.
Well, there is every possibility, and that is the reason I'm here before your lordships under 227. Because
see, 3rd of November, the order was passed. Today we have well past 7 days. Nothing has happened.
No,
adverse to your interest.
No, my lords. They have interfered day before yesterday. The police complaint was given. My lords will see that at page number 102. And given a police complaint as well. Unless they are aware of these proceedings. 102 is the police complaint.
Question is, how do we exercise supervisory jurisdiction in such a context?
If I may only request your lordships to please reduce this order passed previously. It's not binding on my lords. Well, it's page number 2, if I may request your lordships to please take. Well, it's page number 2, the last paragraph. Well, it's at about 10th line, minutes, if I may be permitted to read. It becomes the duty of the courts to examine whether there is any urgency in the matter or not. The court should go through the arguments made by the party in supporting affidavit and also the pleadings and documents filed in support of the case of the plaintiff. When a prima facie case is made out, the court must grant temporary injunction and see the plaintiff is not dispossessed in the meanwhile. The urgency of passing of orders under Order 39, Rule 1 CPC should be kept in mind. Even when the court is not inclined to grant temporary injunction or decides to issue urgent notice, in the case also the court should issue urgent notice and post the matter to a shortest date. The court should examine what is the reasonable time required to serve the notice upon the respondents. When the plaintiff undertakes to serve the notice within 2 or 3 days, the matter may not be adjourned to a longer date. It can be posted within 4 days or a week. When there is an urgency in the matter, the attitude of the courts in posting the matter to a longer date, in fact, defeats the purpose of Order 39, Rule 1. And thereafter, minutes in the next paragraph, which your lordships will see. The learned trial court was directed to issue notice and advance the matter, and in the meanwhile, it was directed that status quo be maintained. This has been a similar circumstance, your lordships, where a suit for injunction was filed and thereafter urgent notice was issued and a longer date was fixed.
That's what I said. That is not there in this case.
But even here, the notice could have been issued to the respondents and it would have been returned within 2 or 3 days because all of them are within Hyderabad. But the matter is now posted to after 3 weeks, which is a long date considering the circumstances of the matter. In fact, similar issue had again come before this honorable court for consideration and same orders were passed. All I'm requesting, my lords, is if your lordships would protect me until the time they come before your lordships, then my lords, the purpose would be solved. Otherwise, my lords, in case if I disposes today, then my lords, this matter becomes infructuous and I will have to initiate multiple proceedings subsequently, your lordships. In fact, if I may share this other copy of lordships, based on this.
Did you offer the personal service upon the respondents?
Yes, my lords. Yes,
is that?
My lords, it is not recorded, my lords, but we have.
Have you treated that in your petition also? Because here also the court has not granted any relief to the petitioner. It has only said that it be taken on an early hearing.
But it's thereafter in the last slide, if your lordships could see, it is depicted that the parties were asked to maintain status quo.
Yes.
Let's another order, your lordships. I didn't. Yes. My lords, may please take the last paragraph, relying on this judgment itself. None single judge had again directed that status quo be maintained and had directed the trial court to take up the matter expeditiously. Unless the petitioner could show before the learned trial court the title for the past 30 years and unfettered possession also matters. In spite of that, the orders were not passed. And thereafter, the interference is continuing.
No, you said you had purchased it only 1 month back.
Yes, I had purchased it 1 month back. I filed the suit on the 3rd of November. 8th of November, they've been interfered. Prior to that, they have interfered. 8th of November, again they interfered. Yesterday, I filed a police complaint. I got this copy yesterday.
Today I move the Laksh motion before my lords. Only requesting my lords that the status quo at least be ordered until then. That's because in fact, my lords, in similar circumstances, your lordships, previously also, the learned trial court was not taking up.
In what capacity are the other side interfering with the same?
My lords, they are the family members of my predecessor in title. Having lost the partition suit and having not preferred an appeal, that judgment is filed and it is recorded that my predecessor in interest was in possession. After I purchased the property, now they are interfering, stating that they are interested in the land. When I filed the order copy at page number 18, your lordships will see that.
When was the partition suit finalized?
I'm just giving the date. Page 68 is the order. I just give the date, your lordships. 2016, my lords. 29th of March 2016, my lords.
No first appeal preferred?
No, my lords. At paragraph 20, your lordships will see that there is a specific observation by the learned trial court that I am in possession of the property. It's the same family members who are interfering with lordships. Like the plaintiff in the partition suit is the first respondent before your lordships. In fact, I had made specific arguments in my IA before the learned trial court, my lords, at page 19 and 20. Bringing to the honorable court's notice as to when they have interfered. request.
Yes.
Then also give me the liberty to agitate for extension of this order before the trial court, because usually what happens, my house, because notice has been issued, when the other side comes, files their wakalat or whatever, then the court would not entertain this. They would say they would have to give them an opportunity to file a counter and thereafter hear the matter finally. That is the usual practice that is adopted.
So now you want this order to be extended till your injunction suit is finally decided.
No, it's just that the court may consider on that day.
Goes without saying you have that right. Who has stopped your right for that? This order you will have to show it to the court below and take advantage of that.
No,
Yes.
Okay. I'm on that.
We please Lordship, I seek the crave of this honorable court to submit my hearing online.
Yes.
My Lord, this CRP is filed against the impugned order dated 4/9/2023, directing issue of arrest warrants against the petitioners herein, who are the legal heirs of defendant number 1 in the suit number 2256 of 2007, in respect of which EP number 69 of 2018 was filed, in which this CRP is prepared. The grounds relied on is, my lord, both the respondents as well as the petitioners are the legal heirs of the siblings. And Order 23 Rule 12 clearly bars that Rules 3, 4, and 8 of Order 23 are not at all applicable in execution proceedings that is not dealt with in the impugned order. And on the other hand, the decree holder, the legal heads of decree holder have examined 2 witnesses. Both have clearly stated that PW1 stated that the judgment data number 6 did not visit the suitable property to deviate the impugned order, and the PW2 says that none of the petitioners are seen at the social property at any point of time. PW2 is the neighbor of the petitioners, respondents, my lord. And without considering the cross-examination in which both the PW1 and PW2 have denied the presence at the social property, EP schedule property, the court below has straight away passed the order of issuance of warrant. I would like to take this honorable court at page number 61, where PW1 says in the second para, that only judgment debtors 7 to 13 have visited along with their friends. But the arrest warrants is issued against judgment debtor number 6, who is the wife of the defendant number 1. And at page 67, PW2 in his cross-examination clearly says that the judgment debtors 6 to 10 and 12 and 13 were not present at any time at any point of time at the EP schedule property.
This OS suit number is 2256 of 17.
Yes, ma'am. 2007, ma'am.
2007.
Yes, ma'am.
The impugned order, first paragraph. Decree is 8/12/2009.
Yes, my lord. In the impugned order, it is also incorrectly mentioned that the judgment debtors 6 to 13, who are the legal heirs of sole defendant. but there were 5 defendants, my lord. Plaintiff and defendants 1 to 5 were all siblings. One sibling files against all other siblings, claiming oral gift in his favor by his mother.
All said and done, there is a judgment and decree dated 8/10/2009.
Yes, ma'am.
Where is that?
That is at page number 34, ma'am.
Plaintiff is Mohammed Usman.
Yes, my lord. He is the brother of defendants 1 to 5, and defendants 2 to 5 were made as not necessary parties to the execution proceedings. But after the death of this Mohammed Usman, Mohammed Mehmood, defendant number 1, against his legal heirs, the CP was filed, stating that they did not try to dispossess them, but they filed a complaint to the police on 10/8/2018, and police took them to police station, and after showing the papers, they left them. That is only the allegation against the judgment data 6/13 in the EP matter. And that was also not supported during the cross-examination when the decree holders' legal heirs were examined as PW1 and PW2. At page 61, the cross-examination of PW1 is there, my lord.
The defendants herein, how are they related to the plaintiff?
Siblings, my lord. Defendants in the suit are siblings, brothers and sisters of the plaintiff. But in the EP, only defendant number 1's legal heirs were made as parties, and the remaining defendants were stated to be not necessary parties, without allowing them whether the legal heirs of defendant number really try to dispossess the plaintiff.
But that order passed, judgment passed in OS has not been challenged.
Was challenged, my lord, but that was confirmed in appeal.
What about second appeal?
Second appeal, the plaintiff did not prefer any second appeal. The defendant number 1 did not prefer any second appeal. In the meantime, he expired, my lord. After the first appeal was disposed of, the first defendant expired, and after that, the CPs came on to the proceedings, my lord.
So the judgment has now attained finality.
Yes, my lord, but not against the legal heirs of the defendant number 1, who are nothing to do with this property, nor they are residing at one place, and the wife of the defendant number 1 was not stated to be present at any point of time in the EP schedule property during the cross-examination, as admitted by the witnesses during the cross-examination, but the arrest warrant has also been issued against her. And PW2 says, except defendant number 6, judgment data number 6, none were present at the EP schedule property at any point of time. He is the neighbor of the decree holder, EP schedule property. Therefore, I pray this Honorable Court to kindly see the cross-examination of the PW1 at page number 67, my lord.
So this suit property which is located in this judgment and decree is presently occupied by
the judgment decree holder, my lord.
You are not in any manner interfering.
The legal heads of defendant number 1 are not in any manner interfering with the position of the plaintiff, my lord.
The petitioners herein.
The petitioners herein, who are the legal heirs of defendant number 1. One thing technically, even under order 33 rule 12, which says nothing in rule 3, 4 and 8 shall apply to the proceedings and execution of a decree or order. That means the legal heirs of the parties cannot be made liable for the judgment obtained by their predecessors who are deceased.
You are making a statement that you are not in any manner interested
Yes,
in
madam.
the property.
Yes, madam.
In any manner interfering with the possession of the original.
No, not interested. There is no admission by the judgment debtors because there is no document in favor of the plaintiff gifting or transferring in his favor. Because all the siblings were fighting with each other with regard to their joint ownership. There is obviously interest will be available for the judgment debtors, all the judgment debtors. But here, the only thing is
that interest will be kept alive only in the event if you challenge the order passed by the trial court. You say
yes, madam. But merely because they are the legal heirs of the defendants, they cannot be made arrested for that status of being the legal heirs.
Once when you say that you are not in any manner interested or trying to interfere with the possession of the plaintiffs in that property suit schedule property.
The judgment debtors 6 to 13 are saying they are not at all interfering with the position of the legal heirs of the plaintiff. But so far as interest is concerned, because there is nothing declared in the favor of their predecessor, that is defendant number 1. They are also not, still now they have not claimed any interest over the property, but during the cross-examination, witnesses admit that the legal heirs of plaintiff admit that the joint ownership claim is still alive, not only among the defendant number 1, but also other defendants 2 to 5 who are the siblings of the plaintiff.
Tomorrow it should not be a case where on one hand you file the revision petition here and on the other hand the petitioners in the revision petition try to interfere with the suit schedule property.
But therefore, that is the ground for which one of the grounds for filing this revision. In Prabhakar Adiga versus Gauri and others case, upon which the trial court relied upon, says that again as the legal heads of the judgment debtors, the execution proceedings can be initiated. But ultimately, what the Honorable Supreme Court found was the trial court was right in obtaining an undertaking that they will not interfere with the position of the decree holder. An undertaking can be taken when there is no proof that the judgment debtors have really interfered with the position of the decree holder or they have tried to dispossess them.
Are you in a position to make a similar undertaking? That you are
yes,
not.
Madam. Yes, madam. We are ready to make a similar undertaking that we will not interfere with the position because the decree was issued and that was fine. That became final in appeal. Their only contention is that merely because they are the legal heirs, arrest warrant cannot be straight away issued. When the witnesses are examined in the EP deposits that they physically did not try to dispossess them or interfere with their position.
Let notice be issued to the
What's your place?
Yes.
Hey, hey, Raghu, what is this one?
Yes, what is this?
This is my application to Google and near for inspection. The other picture, two other side, the picture in the end is tribunal. Criticize them as the full family members. The picture's father will after you given three night. We find pictures to three times, five pictures, prepare some good representatives. The picture is dismissed. They are touching, pay touching your advocacy. They touching the operator part of the matter. Pay touching, one thing.
You are the
So this is, and there is a other card also in sport. To put a tell some sort of receipt person.
will issue notice
Just, yes, I informed the applicant at 10:30 AM. Applicant responded. And that, Mr. Vic responded. He repeated the respondent number 6.
Is he there?
I informed him at 10:15 AM that I request the honorable court for a hearing matter. He said, he is the party, fifth respondent, contesting party. We also advocate, he requires to defend himself. The gentleman will not come, I don't know why. I informed at 10:15 itself.
Venkatesh Deshpande.
Yes, subject this one. And he said this going outside the state, some of the court, he will ask the party himself to prepare because the fifth respondent for a contested party is Mr. an advocate. He said he will research the party prepare as will matter. He himself admitted in his petition another matter that he feels present Krishna comes on with his Krishna. I read that Krishna also.
This Venkatesh Deshpande appears for only one, respondent number 6.
Others are official.
But they would also be required. 4 to 6 would also be required to be.
So, both of them are co-pictures. Both the pictures, respondents are co-pictures with the missing person. They are jointly filed application. The both respondent pictures.
Therefore, notice would go for 4, 5, and 6. 6 has already entered appearance.
There is no conflict of interest. The missing person and both the respondents have jointly applied to the tribunal to recognize them as smaller family members. There is no conflict of interest.
Now that they are respondents over here, would they not be required to be served notice?
There is no conflict of interest.
It is they who have to say. It would not be proper for you to say that there is no conflict of interest with the respondent. They may come and they may make a statement. Let notice be issued to the respondents. Yes, rest we take up some other.
Not permission, extension of entry form.
Item number
53 to 56.
53 to 56.
There, form will extend it.
53 to 56.
Submit this, then the-
Who's on the other side?
Mr. Srikanth Iyer, I'm the plaintiff in the suit your lordship.
No.
Mr. Srikanth Iyer is appearing for one of the respondents. Even before lunch, I mentioned that they take two weeks time for.
Is this case on the 24th November?
Subject to your lordship's kind leave minutes. Let's item number 59, your lordships.
Yes.
Item number 59, my lords have passed an order on 31/10/2023, directing the court, trial court to defer the final hearing date, which was on 7/11/2023, my lords. And the matter is listed on 10/11/2023, and again the suit is posted on 15/11/2023, your lordships.
Yes.
Let's kindly defer the hearing date, your lordships.
You can make the submission before the court below. The order of this court for deferring was for the purpose of hearing that. The hearing has not concluded does not mean every time it has to be extended. You can just inform the court below, it will be accepted.
Very well, minutes. I'm obliged.
We are listing it on the 17th of November.
obligement.
Item 52.
Allowed one submission.
40
Allowed one submission. Item number 82.
Or 72.
14th and 17th both are back. We have it on 24th.
This is a which showcase.
17th and 24th, nothing is going to happen. 24th.
Item 61.
Allowed item number 84, 82.
82 or 84?
82, my lord.
82, yes.
Last occasion also not reached.
You could also not reach today.
Yes, my lord, yes. So
When?
it is only a case in relation to the getting certified copies from the lower court, which was not furnished. CRP arises non-furnishing of certified copies.
Next Friday you will be there.
Please, my lord.
Yes, we'll have it on 17th.
Please, my lord, please. But the learned judges reserve the matter for judgment. You have to kindly post the matter to 14th to 17th to 27th.
Which page, item number?
41.
40.
The very CRP will be rendered infectious.
Yes, sir.
Yes.
The other states third copy on me also.
Because the caveat expired in same or not.
40 so and so for the petitioner. Just give your name on a slip of paper, it will be reflected. The office is directed to reflect the name of Sri so and so as the counsel for the respondents in the cause list positively on the next date of the year.
But 17 not 90%.
17.
Item 58, 61, 58,
40.
41 or 40?
41.
41. 41.
Yes.
item number 61.
Yes.
It is maintenance variance of 50 lakhs, which is your last 6 adjournment over. Respondent. Item number 61.
Who's there for the other side?
Reddy Ramchandra. Not appeared.
Any interim is granted? No.
Not yet, not yet.
We'll have it on 24th of November.
Much.
61 on 24th of November. I don't have any difficulty in posting. The only difficulty is whether it will reach or not. 17.
Because it is an urgency, the eviction is there. That's why. It is a rental quick.
Yes.
70.
Yes, it will be.
Item 75 and
75 and 76.
Can go to a partner date also.
Who's on the other side?
None appeared in spite of service of notice.
22nd of December. 22nd December.
Right.
Yes.
Such motion that has been mentioned by the council, there was one point that is missing, that the appeal that has been filed before this report that has been returned multiple times here. So that is the reason why we are ready to take the award subject to
Return for?
the lunch motion that
No, return. The appeal has been returned for?
a return for non-compliance, of some objection that has been raised.
It has not been really returned. It has been listed on 512 for clearing certain defaults that are reflected in the 34 application.
There was some difficulty.
That would have to be secured. It is not that return of the application. There is a fixed date given 5th of December. I have doubt on the jurisdiction of this court itself. How do I grant an interim protection? Difficult.
Item 58.
Yes.
Interim order, sir.
58 interim to continue. Who's on the other side?
Again.
Yes, Nagesh. Yes, Nagesh. You'll have to inform him.
Yes.
Please do inform him. 1st of December. Yes. Everybody else.